When an elderly person with a joint bank account dies, do the funds belong to the decedent's estate or do they belong to the additional signer as a co-owner of the account? In estate, trust, and elder financial abuse litigation, dueling advocates argue over what acts are within the traditional statement of law and what are outside the so-called black letter rule. This is the battleground for how to apply the law to different factual scenarios. In the real world of joint account disputes, the factual spectrum of intent, timing, and original depositor vulnerability is very wide. When was the account formed? An account formed with an elder with Alzheimer's 3 weeks before his death is quite a lot different than an account formed with an active and attentive elder long before the elder's death. It's one thing if the elder never expressed an intent as to the account's purpose, and quite another if that elder made his intent clear that the account was for the use and ownership of all the parties to the account. The question of vulnerability to undue influence can thwart the ambitions of an elder financial abuser. The factual elements of a successful California elder financial abuse claim against an abuser include proof by a preponderance of evidence, not clear and convincing evidence, that an individual and or his or her assistant took, hid, appropriated, obtained, or took the decedent's property. The victim, the decedent, was 65 years of age or older. The taking was for a wrongful use with the intent to defraud or by undue influence, and the decedent was harmed. So while an abuser thought they could get away scot-free, their scheme can be upended by an elder financial abuse action. The abuser will find it difficult to hide behind the more burdensome, clear and convincing evidence standard applicable in a simple probate account dispute versus the more likely than not or preponderance of the evidence standard in the civil courts. Law firms like Hackard Law that focus on estate, trust, and elder financial abuse litigation must know and apply far more than black letter law. The law can be nuanced and wholly dependent on the particularities of each case. The life of the law has not been logic, it has been experience. Oliver Wendell Holmes, Jr. Experience counts in most human endeavors. If you'd like to question us at Hackard Law about a particular estate, trust, or elder financial abuse matter that you or a loved one is experiencing, then call us at 916-313-3030. We represent clients throughout California, including in Los Angeles, Sacramento, Santa Clara, and Alameda. We look forward to hearing your story. Thank you.